back with you here on the Newsfeed PM. Thanks for staying on. We go to this story now. The EFF says it has taken legal action to defend what it calls the integrity of the South African public institutions by approaching the High Court of South Africa to review and set aside the unlawful, irregular appointments of multiple sector education and training authority SETA chief executive officers by the Minister of Higher Education and Training. For more on this, joined now by Sihle Lonzi, who is EFF Member of Parliament. Sihle, good to have you, and thank you very much for your time. From what we can understand, as far as the timeline is concerned, is that the minister, I think on the 1st of October last year, just one day after the new boards, accounting authorities to these SETAs took office, he took some action and appointed CEOs to these institutions. What is procedurally unlawful about that process?
Thank you very much, Thabo, and good afternoon to the viewers and at home. The minister simply can't explain. You remember when we summoned the minister to appear in Parliament last year, and we asked him, Minister, these are new accounting authorities. You've just appointed them on the 29 September, if I've got the date correctly. And immediately after appointing them, you send them a letter and say they must convene so-called urgent accounting authority board meetings. And in less than 24 hours, you want these people to recommend to you whether or not you should extend the term of office of CEOs for an additional term of 5 years. There's no recruitment, there's no selection committee process, there's no shortlisting process. There is simply no ways that the accounting authorities would have reasonably and rationally been able to take that particular decision to extend the term of office of these CEOs without having applied their minds correctly and gone through a proper recruitment process. Even if it's internal, I made the example last year that we know, for example, if you look at institutions of higher learning, a council can extend the term of office of a vice-chancellor, but it must still undergo its own vigorous process. Yes, it may not necessarily going outside, but even internally, we must check what has been the performance of the vice-chancellor. You must consult the Senate, you must consult the IF, you must consult various stakeholders within the institution. We don't believe that any of that happened. We believe that the minister, after coming in when there was a SETA crisis with the former minister, he goes and continues in the same patronage, in the same flaunting of processes, in the same ignoring of important processes that must take place in order to further the patronage and the corruption in the SETAs.
So you're saying, I mean, according to the timeline here, on the 29th, the accounting authority is in place, and then you have the 30th, and then it's the 1st of October, the minister then appoints 7 CEOs. Now, according to the Skills Development Act, there's a particular process or steps that must be followed. I don't know whether these must be strictly adhered to. One, the accounting authority must recommend 3 suitable candidates to the minister. 2 consultations. The minister must consult with cabinet regarding the recommended candidates. And 3, then final appointment. The minister makes the final appointment. Are these steps that must be strictly adhered to? And you believe that in the day, on the 30th, this would not have been possible to happen?
Look, there are 2 processes that the Skills Development Act stipulates. It says that you've got the one process which says you must release an advert, you must shortlist, you must recruit, and that would typically take about 6 months. And then under Regulation 8, it then says if the AA would like to recommend to the minister an extension of the current CEO for a further term of 5 years, the AA must then make those particular motivation. And you're quite right. After having consulted and gone through various stages in saying this CEO has been here, they've checked the history. I mean, if you look at some of the history, financial history of these SETAs, which were told that the CEOs are coming back, the AG would never agree with that decision. They've been getting qualified audit outcomes, others with like gross findings of mismanagement of funds, irregular SCM processes. So Even if they had spent a long time to decide whether or not they want to bring some of these CEOs back, by their own record, they would not pass the test. But we're saying, let's assume they would have passed the test. How does the minister undergo all of that in less than 24 hours? Because these people coming on the 29th, the minister sends them a letter and says convene a meeting. The likelihood is that they would have convened one meeting. And already the minister has given names and is appointing those particular CEOs. There was no process which could have been followed in that short space of time. The minister would have known before that there are certain people, certain CEOs, either because they are his comrades, either because they are friends, of whatever relation that they may have, that he wants to keep. Why not just open the process up? We've got 21 SETAs, already in 13 of them, or 14 of them, you are undergoing a recruitment process for CEOs. Why not just open up? Even if the current CEOs want to come back, why don't you subject them to the scrutiny and subject them to be tested with everyone else who would like to be a CEO of the SETAs? If you are not scared that these people, the track record is not good, why do you want to put them at midnight when people are sleeping and not follow the processes that are there?
Any response to your corruption concerns? I mean, you're saying, for instance, some of these administrators are linked to mismanagement cases involving millions. Linked, of course, does not necessarily mean that they've been found guilty at this particular point.
Look, if you are a CEO, you are the one who must take accountability for the day-to-day operations of an institution. If the AG comes and says, for the past 3 years or the past 4 years or 5 years, this institution has been getting, qualified audit outcomes with findings, you ought to take accountability as the CEO. Of course, together with your CFO would be in charge of finances. If the AG comes and says you've not been following SCM processes, you've been flaunting, those are operational issues, because the board would have a fiduciary responsibility to meet every now and then, but every quarter. But a CEO is in office every day dealing with the day-to-day operations of the company, or rather of the SETA. So if the SETA is not performing, then the CEO must take responsibility. But we're not even at that debate yet. Now we're still dealing with the process. I was just raising as an example to say some of these CEOs don't even pass the test, but we're not even there. At least, had the minister followed the process, maybe we would be debating the caliber of these CEOs that he wants to appoint for an additional term of 5 years. We are now discussing the process, and we're saying the process that the minister claims to have followed does not pass the rationality test.
There's a perjury issue as well. How is that perjury case coming along?
The perjury case is coming along very well. We don't want to reveal everything, but we've been sent the investigation officer by the South African Police post station in Cape Town, and we're working it. So very soon you are going to surprise. We may have a third minister of higher education in South Africa, because clearly these two who have come in don't know what they're supposed to be doing in the position.
Now, you are heading to the High Court. What are you praying the court will do?
Well, we're praying that the court sets aside these decisions, a judicial review, and allow the minister, or rather force the minister, to undergo a transparent process in the appointment of SETA CEOs. I don't understand why it becomes so difficult for these ANC ministers to just simply undergo a transparent process. Because if they trust that these preferred candidates, these children of theirs that they like appointing in the SETAs, these family members, these comrades, are of the standard, why can't they apply like every other South African? Why can't we just open up the process and allow all? We're not saying ANC members can't apply for positions. We're not saying children of ANC ministers, family members of ANC ministers can't apply for positions. We're not saying that. But we're saying they simply can't be allowed to jump the line. Why can't they apply like all of us who are applying and be subjected to the same scrutiny and be subjected to the same recruitment process, the same shortlisting process, the same interviews like all of us, so that we can get the best amongst those who have applied? So we want this decision to be set aside so that we can get a proper process in appointing CEOs, because it is these CEOs who are appointed through devious means who end up collapsing our SETAs. In the SONA, the president said there's going to be a reform, there's going to be a restructuring of the SETAs to align it with our nation's skills development program. But we're never going to be able to do that if we're still entrenching corrupt patronage in our SETAs, if we still don't want to do things transparently, if we still don't want to follow processes. Yeah. We can write all sorts of gazettes. The president of the country can make all sorts of pronouncements. But if even at a leadership level, the minister is not willing to subject it to a transparent and open process, then we're never going to get the SETAs right. And if we don't get the SETAs right, we're not going to get our nation's skills development program right.
Yeah. I don't know how the response of the minister's office is going to be legally to this matter that you are bringing, but I'm just imagining. The minister could say specifically, these are not new appointments. These are reappointments of 7 CEOs. If we would have, as you put it, this process, gone through this process, it would mean for 6 months, these particular institutions would be left without leadership.
So the Skills Development Act provides for that. In fact, any institution would provide for that, to say that even during the period when you are looking for a CEO, I mean, if I don't know how things operate at Newzroom, but I imagine there's no lull when you want to bring in a new leader to come and take over and become a CEO or a manager at Newzroom. People can act, but in any case, these were supposed to be made long before the term of office of the AAs came to an end. But we understand the chaos that happened last year, which was created by an ANC minister, by the way, which caused the delay and now has put the minister in this difficult place of appointing CEOs. But just because there was a delay in the appointment of CEOs does not mean we must flaunt processes when we reappoint the CEOs. I agree with you with reappointments, and I made the example with institutions of higher learning. There's nothing stopping the minister from reappointing a current CEO if the board believes that this person is performing, this person has been doing well for the entity, is growing the entity is in a good financial standing. There's nothing wrong with bringing, but even that decision must undergo a rigorous process so that we can say this CEO emerges as the best amongst all others who would have wanted to be CEOs internally in the company or externally.
Sihle Lonzi, I appreciate your time. Thanks so much for coming on. He's the Member of Parliament for EFF Sihle Lonzi there on them challenging the appointment of 7 CEOs at SETAs by the Minister of Higher Education. They are taking that particular matter to the High Court. We'll go to sporting news after the break. Do stay with us.